me to briefly introduce Professor Giorgi Parulava and his impressive academic and professional background. Talking about his education, Professor Parulava has been a part of Stockholm University since 2021. He is a doctoral candidate and faculty member at the Department of Law examining legal implications related to extraterritorial application of the European Union's Artificial Intelligence Act. He is also an affiliate doctoral student at WASP-HS Graduate School and the Swedish Law and Informatics Research Institute. He also holds an LLM degree in European Business Law, specializing in EU Internal Market Law, EU Competition Law, and other related fields since 2017. About his work experience, he has been a part of EU's MSCA-funded Innovative Training Network, RISHALS, as well as a co-founder and researcher at Law and Innovation Research Center. He served as a leading specialist in Economic Department of the Georgian Competition and Consumer Agency. Earlier roles include Legal and External Counsel at Capista LLC and Legal Counsel at Georgian Bakers LLC. His career began with a foundational experience including an internship at the US Embassy in Georgia's Public Affairs section, where he gained insights into international relations. He also demonstrated leadership at the head of the legislative group at the Students' Constitutional Commission. Please join me in welcoming Professor Giorgi Parulava for discussion on AI risk categorization from an EU law perspective.
Thank you very much for a warm welcome, and I'm very pleased to be here. I'm a doctoral candidate at Stockholm University, but I'm also involved in a SPARK project, which is jointly conducted by SLS Pune and also two other European universities, which is Stockholm University and the University of Milan from Italy, and together with the leadership of Professor Gurpur from SLS Pune, we are looking at healthcare and patient safety domain and the potential harms generated by artificial intelligence technologies in that domain, and we are primarily looking on legal and ethical issues there. So I have been based in SLS Pune for 2.5 months now, and this last week I've been traveling a little bit in sister institutions. So I went to SLS Noida and SLS Hyderabad, and I also had lectures for your colleagues, and this is my last destination, and I will be delivering 2 lectures here. So as I mentioned, the SPARK project primarily focuses on AI legal issues in the patient safety domain. So I will be talking about those topics today, but I also heard that you are, at least most of you are first-year students. So I tried to make the presentation quite basic, so I will try to cover fundamental aspects related to artificial intelligence and the issues related to regulating artificial intelligence and some of the possible approaches how we can regulate AI. I will also talk a little bit about the concept of patient safety and the problem of regulating patient safety, and also I will talk about the European Union law and the difficulty of covering these topics by the existing EU law because of its complexity and the potential conflicts and legal issues that might be present when we talk about regulating artificial intelligence. I'm not sure if you can see on the screen, but just to quickly go through the structure of today's presentation. So I will start by talking about artificial intelligence fundamentals and the concept of artificial intelligence and definition. Then I will talk about patient safety and risks related to patient safety. As we will see, the risks are very significant for patient safety and also for artificial intelligence, and we will also see that European approach to regulating artificial intelligence is largely a risk-based approach. I will also talk about the European Union law and patient safety, and then I will move to the main part of my presentation, which is European Union's upcoming Artificial Intelligence Act and patient safety, and I will discuss the risk-based approach established by the European Union's Artificial Intelligence Act. And finally, I will talk about some of the legal challenges and legal problems. So I'm currently working on a paper which I plan to publish in the next 2 months for the SPARK project, and it's going to be about patient safety and the risk-based approach. So I will talk about the primary legal challenges I see in this area, and which hopefully I can address in my paper. Yes, so let's start with talking about artificial intelligence. So the term artificial intelligence originated from 1954 from Dartmouth seminar in the United States. So the very basic idea of artificial intelligence was built around the thought that systems and technologies can have the similar intellectual capacities as humans, and they can basically think and perform tasks like humans. And they also coined the term artificial intelligence, and it's been a few decades since then, and it's been a constantly evolving term because of different approaches and also because of the different technological capacities of those systems. So some of the characteristics to the artificial intelligence concept could include the simulation of human intelligence. It encompasses the simulation of cognitive process, including learning, reasoning, problem solving, also perception and language understanding, and all these tasks are executed by machines. There's also a concept called the behavior mimicking, so it involves the development of algorithms and computational models enabling machines to mimic cognitive functions associated with human intelligence, such as perception, reasoning, learning, and problem solving. So again, it's like a human kind of behavior. Also, building these systems is very important as well. So with progress related to technologies and computing power, these systems could become more intelligent, because first initial systems were not that smart, so they had some basic intelligence, but not super smart. But with the technological progress we have today, and the amount of data we can have, and the computing power we can have, these systems could become extremely intelligent. As we mentioned some of the characteristics of these systems, we can now move to a definition of artificial intelligence. And definition is very important for us, for lawyers, because it largely limits the scope of application of laws. So if we have a too broad definition of AI, then we can potentially capture all kinds of systems by this broad definition. And for example, some very primitive software systems which do not have very high level of intelligence can be captured by the broad definition, while on the other hand, if we as regulators come up with very narrow definitions, it could be possible that some of the AI systems will not fit into this definition. Then we will have the under-regulation problem, so we won't be able to apply those to certain AI systems because of a very narrow definition. So AI definition has been the subject of fierce debates, both on scholarly level and both on political and regulatory level. And as you can see, AI systems are quite international and broad in the sense that they can be applied in all domains, whether it's healthcare, financial sector. It could be applied cross-country circumstances. For example, AI services could be provided from India to European Union. Also, these kind of products can be sold internationally. So both in terms of its geographical scope and its functionality, AI systems are very broad in nature. So that is why it was very important to have some common understanding and a common agreement when it comes to AI definition, and international organizations such as Organization for Economic Cooperation, OECD, some of you might have heard about it, plays a huge role when delivering AI policies and AI definitions. So the current definitions we have are largely influenced by OECD and basic AI definitions suggested by the OECD. So the primary legal instrument when we are talking about AI, we have this European Union Artificial Intelligence Act, which is the main topic of our today's presentation, and it provides the definition of AI. So we will read this definition, and we will also discuss some of the very important elements covered by this definition. So according to the European Union's Artificial Intelligence Act, which dates from 2024, AI system means a machine-based system that is designed to operate with varying levels of autonomy and that may exhibit adaptiveness after deployment, and that for explicit or implicit objectives infers from the input it receives how to generate outputs such as predictions, content, recommendations, or decisions that can influence physical or virtual environments. So as you can see, it's quite a big definition and encompasses different elements. So the first element I would like you to pay attention is that this system has to be a machine-based system. So when we talk about different systems, they can be based on human-based system. Also, so the humans play a role when we talk about outcomes of both systems and how they operate and are deployed. So when we talk about AI, this has to be a completely human-based system. Then the second important element is the right level of autonomy. So AI systems should encompass a certain level of authority, and when we will discuss the issues about categorization of these systems based on risk, we will see that different AI systems can have different levels of autonomy. So the higher level of autonomy the systems have, the more advanced the AI system is. So this is once again linked to the definition and scope of application, because besides very intelligent systems, we can have very basic software systems just to perform basic tasks, and those systems normally don't have high levels of autonomy. So one way to differentiate AI with basic software system could be the level of autonomy they demonstrate. Again, the goals of these systems could be explicit or implicit objectives, and it infers from the input it receives how to generate outputs, and the outputs could be predictions, recommendations, decisions, and so forth. So again, when we talk about AI, two important phases are necessary to consider. First is the input level, so how we train AI, what we put it, how we build it, and then the output it generates, and output could be in different forms, whether it could be a final decision or just a recommendation, and so forth. And again, based on the level of autonomy, so we might design AI systems to perform one task or another, but if it gains a high level of autonomy, it could broaden its scope and come up with the output we didn't even consider when we were building these systems. This could be especially relevant for general purpose AI systems, but we will talk about the general purpose AI models a bit later in our presentation. So this is basically what is European definition of the AI system, how it looks like. We also have an American approach. It's called President Biden's order on artificial intelligence, and it is, we can also read it, but it is very similar to the European approach, and both of them, as I mentioned in the beginning, were influenced by the OECD recommendation of defining AI systems. So according to the Biden's AI order, AI is a machine-based system that can, for a given set of human-defined objectives, make predictions, recommendations, or decisions influencing real or virtual environments. Artificial intelligence systems use machine and human-based inputs to perceive real and virtual environments, abstract such perceptions into models through analysis in an automated manner, and use model inference to formulate options for information or action. So this is again a machine-based system. Both input and output levels are important, and it also demonstrates a high level of autonomy. So as we define AI systems, now we move to our legal parts of our presentation, and now we have AI systems which are going to place on the market, and how we as lawyers and as policymakers are going to regulate artificial intelligence. So there are different approaches, and none of these approaches are comprehensive and provide final solutions, but this could be tailored to the legal landscape and the particular reality of each country and the existing laws this country has. So there is no universal approach, but I will just try to briefly go through these different approaches. So one is the hard law approaches, and hard law approach versus the soft law approach. So for example, European Union decided to go towards the hard law approach, and this means that European Union established its regulation, which is very comprehensive and broad in nature, and the hard law in this sense means that this regulation is mandatory for all European countries, 27 member states, so this is a mandatory law. The soft law approach could have been that instead of regulating artificial intelligence on European level, the European Union could have come up with softer approaches, such, for example, recommendations or sectoral standards and so forth. So the difference between hard law and soft law is important. Both of them have benefits. For example, soft law could be more flexible and could be particularly tailored to specific sectoral needs, while hard law could establish a more harmonized approach when we talk about regulating AI. So keep in mind, if you are coming up with some kind of a regulatory approach, what kind of approach could be best suited for your current circumstances. That is one important difference between approaches. The second approach is the difference between a rights-based approach and risk-based approach. So European Union in this regard decided to go towards the risk-based approach. So this, what's the difference and what does each of it mean? So a risk-based approach is more common for product safety regulations. So basically artificial intelligence in this regard is seen as a product which is going to be placed on the market, and before the certain products could be placed on the market, it should be checked what kind of risks they can potentially produce before they can reach the final consumers. So for example, when we talk about medical devices, before they can be put on the market, the potential risks should be assessed. Or for example, when we talk about toys for children, they should be checked before they will be placed on the market, so we don't harm children and so forth. So this rationale is borrowed from the product safety regulations, while on the second one is the rights-based approach, so it means that basically the patients in the healthcare domain, for example, or consumers have certain rights, such as consumer rights or human rights and rights to be safe and so forth. So human rights-based approach is built on the idea that I as a human have certain rights, and these rights can be applied in the artificial intelligence domain. So primarily EU approach is a risk-based approach, but also has some rights-based elements to it because it's later implemented human rights considerations into the Act, but we will also talk about this later. Just for you to sum up, these are two main approaches based on the risk and based on the rights. There is also a regulation versus innovation approach. This could be very important for policymakers because, as you can expect, these AI technologies have huge potential in various domains, whether it's healthcare, financial sector, or so forth. So, first of all, they provide new and unprecedented solutions to the existing problems we face as a society and as policymakers. So they can solve some of the problems which were not possible to solve before. And also they have great economic potential and business potential, so they improve economic environment and economic reality for many people and many